2 o'clock, which means that we're here with Sharon Bassan. And welcome, Sharon, to the conference. And just a couple of housekeeping items before I introduce you. First of all, I'd like to thank those of you who are attending the conference today. And if you have, I know that there are a lot of concurrent sessions and that you have to choose among sometimes a variety of topics. So if you miss a particular session, you can always catch up with it after the conference because we're recording everything. If you have any questions, comments, or observations for our speaker this afternoon, you can do so using the Q&A feature in your Zoom dashboard. If for some reason you do not have the Q&A feature, the chat is active, I know, so you can also mention things in chat. Welcome again, Sharon Bassan. Sharon is a legal scholar with expertise in bioethics and ethics, health policy, innovation, and information technology law and ethics. She is currently the Jaharis Faculty Fellow in Health Law and Intellectual Property at the DePaul University College of Law, after 2 years as a Postdoctoral Research Associate at the University Center for Human Values, UCHV, Princeton University. Her research addresses emerging technologies that lack a clear regulating authority or a cohesive regulatory framework, which raise ethical challenges and often commercial interests. Sharon's recent and forthcoming work explores the regulation of reproductive practices and information technologies, such as data mining, big data, and intelligent systems. Her book, Regulating Cross-Border Surrogacy, is forthcoming at Cambridge University Press. Welcome again, Sharon, and the virtual floor is now yours.
Thank you very much. Thank you for having me. This is a real pleasure. And what I'm going to do today, although I'm a legal scholar, I'm not going to talk legal talk, but I am going to tell you a story. And what I want you to do is to listen to the narrative and think how the forms of speech, the different narratives that we hear contribute to the way that we conduct practices and the way that we treat certain ethical questions that we have. So I'll just share my screen here. Tell me if you can see it. Let me see.
Yes, we can see it just fine. Thank you.
Sorry. Okay, good. So I'm going to talk to you today about a court ruling from 2020 with regards to surrogacy. The court addressed a question of gay eligibility to domestic surrogacy in Israel. However, in order for me to tell you the story of this court ruling, we have to go through certain stages. So again, this presentation is a presentation, but what is important is the narrative. So think about it more as some sort of an audio story that I'm telling you. We're going to address several chapters, if you want, in our story, right? So first of all, I will review some general concerns that we know about surrogacy, that we have about surrogacy, and how and what the implications they may have for the regulation of surrogacy practices. I'm going to talk about reasons for medicalization, just because I know that medicalization has been a strong issue in this conference. So I wanted to kind of surface these topics a little bit more, and how they are contractually entrenched in the practice. And then I'll give you a little bit of necessary cultural and political background about Israel for us to be able to address the ruling of the court. And the main part will talk about the court's ruling that I want to address, okay? So the first question I would have asked you if it was a little bit more interactive, and you can maybe answer me in the chat, is what is the subject of surrogacy contract, right? What are we transacting here? And there are many possible conceptualization of this transaction, right? We can say that we are buying babies, right? We can say that we're paying for uterus services, like we pay for maybe for other bodily services. We can say that this is a labor contract, right? That this is a work contract. Just like many other bodily works that we know of. And we can say that we are actually transacting a parental rights, right? We're taking the parental rights from the woman who is giving birth and transferring them to someone else. So I'm going to address some of these things, and I want to ask whether these some of these discussions should cause us to abolish or to object to surrogacy markets, right? And I'm going to talk about these four arguments at the beginning, okay? So harmful medical procedures, inalienability, commodification, and slavery, okay? So we could say that we should object to surrogacy because surrogacy commodifies babies, maybe it commodifies future life or the surrogates themselves. All of these harm the dignity of human beings and should not be allowed in a market. Maybe we can allow altruistic options, but the commodified market is a problem, right? And we should ask ourselves, are we really commodifying this? So it depends on how we look at things, right? So for example, if we look at the contract and we see the way the payment is constructed, the surrogate is not getting fully paid until she has delivered the baby to the parents, right? Relinquished her rights, but also delivered the baby. So if we're talking about completion of this transaction, baby must be involved. So maybe we are commodifying babies. Is that so wrong? Aren't we commodifying many other things? Aren't we commodifying many other future life aspects? We may be. So maybe this is not convincing enough to abolish this procedure, but maybe we should ask ourselves how we manage it to do it different. I don't know. I leave this question open. What about harmful medical procedures? So there are a lot of risks in pregnancy. We know those risks, and more so when it is through the process of IVF. Depending who is giving the ova, we may have hormones involved. There is monitoring. There are some restriction on behavior. There should be a medical. Sometimes there may be medical intervention. So the first question that we want to ask is this procedure too risky to allow? But we know it isn't, right? Because if a couple is having a problem of getting pregnant, we're allowing them to undergo an IVF, right? There's no problem with undergoing the procedure as such, right? So what is the problem? Is the procedure too risky to allow when I'm undergoing the procedure not for myself? Like, is it not okay to allow women to get into these risks for someone else? So the question is, what does it matter, right? We don't want to risk women if it's safe enough for a woman to undergo this procedure for herself. Why should it be more risky or differently risky when she's doing it for someone else, if this is what she wants, right? The idea is that women are allowed and are sufficiently protected to undergo IVF. This is the kind of the bottom line that the public policy shows us, right? So the question here again is the procedure too risky to allow when undergoing it for someone else for money, in exchange of money? So we can say that this is the problem, again, the commodification of the body is something that includes risk. But I think that if we look at many labors and many works, many kind of jobs, there are many kind of jobs that put women and men in risk for someone else, for someone else's profit, if you want. So here, when they're not doing it for profit, one might say they're even doing it for something that is more noble and more important than profit. So this by itself, I don't think this is very convincing. Then there's a question of inalienability. So alienation is something that Marx talks about. It's the phenomenon of being and feeling separated from the product of one's work that should belong together. And the discourse, we know the discourse from talking about many other things like prostitution, for example. And the idea is that, as Kant says, everything has either a price or dignity. If you're selling parts of yourself that cannot be separated from yourself, you're actually selling yourself. And the only way to do it is kind of to separate yourself from part of yourself, which is impossible. Therefore, surrogates are being objectified as vessels or reproductive prostitute, and it requires from them to detach from things that belong to them that are kind of undetachable. Okay, and again, I think the main thing that is unconvincing here is that empirics shows that women may have very different experiences, right? So some feel very detached and very emotional. Some are not, as in many other things in life. So as a general argument, of course, it has a lot, and of course, we have to minimize the fact that, or to minimize harmful consequences, but not all women have problem with this. I would also say something, the example that I used to give about it, if setting something personal is wrong, the thing that should be most objected would be selling art. There is nothing more exposing than an artist putting their soul on the canvas. Yes, we allow them, yet we allow them to sell very personal things. So just the fact that you are selling something that is so personal does not necessarily mean that this is wrong. Okay, of course, it's not the body. I totally acknowledge any potential criticism on that, but even, you know, that we can talk about athletes and we can talk about models and about all the other things. The next one would be that this is forced labor. This is forced labor because it requires a very strict control over the production. The production is the woman's body, surrogate's body. And it gives maybe the employer or someone you're contracting with a very, some sort of monopoly over the control of your body. And we know that inherently surrogacy requires that women would be subjected to medical scrutiny and medical monitoring. We have to do it for the safety of the uterus, of the surrogate and the fetus. So both of them require this scrutiny, and there is kind of no way to get out of it. This may be not there may not be, if this is wrong, there may not be a way to do it otherwise. This is kind of a necessity. On the other hand, we can say that just like in many other jobs or many other contracts that limit some of your control over your body, any work contract really limits some of your control of your body. You cannot go anywhere. You have to be at work. You have to perform. If your work is a bodily work, something that you use your body to do, you must do what you are required to do, and you don't have all the freedom that you want in the world. So maybe this is not extremely convincing. How about slavery? So the strongest point of so the idea is that surrogates enter the contract willingly, right? So they freely choose to enter the contract. But then once they're in the contract, A, they're controlled, like we talked before. Their body has to be controlled in some way. And B, they don't really have an option to go out unless they pay very heavy price emotionally and physically by doing an abortion. If they're allowed, they're not always allowed by the rules of the country, by the laws of the countries. So is it really self-submission? Am I really willingly kind of putting myself there as some sort of a slave? I find this unconvincing because the whole idea of slavery is that you lose your future autonomy. You lose your right to use your future autonomy. However, in surrogacy, we're talking about a fixed term. Even if you lose some of your autonomous will for some time, you're not losing it completely, and you will regain it when the contract is over. And if we believe that there is some sense in making contracts and restricting what you're doing for the sake of the contract for a certain period, then I think that this works within this paradigm. So far, the first kind of general concerns that we hear about when we talk about surrogacy, we have that. Now let's talk about how the contracts entrench this kind of medicalized view of surrogacy, right? So the idea of the contract is that they tell they kind of manage expectations, they manage risks, and both parties have a lot of risks, right? So the parents are really terrified that something would go wrong. Oh, I'm sorry, that something would go wrong, that maybe the surrogate would not give them the baby at the end. She will maybe change her mind. She will maybe risk the pregnancy. So a lot of these things are being translated by agencies and lawyers to kind of a very big checklist when there is a tag price for every little step in the way. And everything has a price. A sociologist from Irvine University said that basically the contract reflects the fears of the intended parents. And we can say a lot of things, but if you were on the side that thinks that commodification is very, very wrong, then the contract definitely objectifies and commodifies every step of the way. Everything has a price. And many of the fears that are translated into the contract are not even enforceable. However, they sort of make a little bit more, that make the intended parents a little bit more at ease with kind of having some sort of control. On the other hand, we know that surrogates are not entering this unwillingly. They should know exactly what is in the contract, right? So the idea is, and definitely in the United States, the kind of the status quo is that the surrogate has her own lawyer and they should make sure that she's aware of everything. And if we're talking about contractual benefits and restrictions, that she sets her boundaries, right? So for example, the request to have the surveillance cameras in surrogate's home was kind of pushed back by surrogate's lawyer. So there is some sort of a limit to what can happen, right? Basically they, I went through that, I'm sorry. Okay, so this is what we have here. We can ask ourselves whether stating everything in the contract is actually empowering the surrogate, because now she knows what she's getting into, or whether the fact that everything is kind of laid out in the contract like this with a tag price is actually the problematic part, the commodifying and the degrading part, and maybe even more so for some things that are non-enforceable. For example, many of the contracts talk about the surrogate not having sex with her husband or something like this, whether this is empowering or degrading. So we finished the first chapter of our story, and now we're going to the third part, and this is where I give you a little bit of background about the political and cultural state, positions around surrogacy in Israel, so we can understand the ruling better. So Israel is today, by the way, is the Independence Day, so happy birthday to Israel. Israel is constituting itself as a democratic and Jewish state. As such, it has kind of a schizophrenia a little bit. As a democratic state, it holds very liberal values about freedom and equality and autonomy. And this is reflected in many of the laws that Israel has and in many of the approaches. On the other hand, it is also Jewish. As a Jewish country, it may have a little bit more kind of conservative and religious views about certain things. However, this does not necessarily mean that there is a problem with reproduction. Why? Because the Jewish religion is very supportive of reproduction. I have written a paper about it if you want to check it out later. And there is a very clear pro-natal approach, right? Just make as many children as you want, and we will support it. Therefore, Israel is kind of the head of the spear when it comes to reproductive technologies, right? So the first thing that happened is that in 1991 there was a commission discussing reproductive rights and reproductive issues, reproductive technologies. The approach in this commission was extremely liberal, right? And as part of the commission, they were, of course, acknowledging surrogacy as something that reflects women's body over their body, autonomy over their bodies. This is a completely legitimate decision, and they were really pushing towards approving that. This raised a problem for radical feminists who talked about issues like power dynamic and commodification and things that may push women to these situations that will put them in an exploitative state. So when radical feminists saw that they cannot really kind of move the liberal approach from the table, they said, okay, we're going to join the table and we're going to make sure that the law will have as many protections for surrogates as possible. So in here, you can see all the protections that they managed to put in, right? So contract should be reviewed, ensuring the rights of all of the parties. It must be approved by the court. It will have some, it must have some rights to terminate the contract if the surrogate wants, and the surrogate should be represented by her own lawyer and choose her own midwife, etc., etc. So they did manage to put in some very fruitful protection input and protections to surrogate. And the main idea is that egg retrieval and the artificial inseminations are publicly funded, because Israel is the country that funds assisted reproduction more than any other country. And we have national health insurance. So everything is publicly covered by the health insurance. The payment to the surrogate itself is what the intended parents have to put in. And this kind of varies. There's some sort of range, but nothing fixed other than by practice. So practice does set a certain price, right? And everything else beyond the medical issues and the payment to the surrogate is also paid by the intended parents. So the only thing that they could not pass in 1996, when they legislated the law of agreement to carry embryos, that I'm going to call here the surrogacy law, the only thing that they didn't manage to pass was that it will be open to all. Why? Because at the time, they thought that this is an unusual, kind of a drastic, extreme procedure, and we should only allow it to people who have medical problems. Therefore, cultural reason to use surrogacy, like same-sex couples or single people, were not considered important enough to take part of this thing, right? And this was also kind of the power of the more Orthodox Jewish parties in the parliament that did not allow that. And then, okay, by the time that we're talking, so after in I think 2014 or something like that, there was another commission considering reproductive issues, and they were talking about expanding the eligibility to gay people. And here's where we go to really the kind of cultural background. They were talking about it, but it didn't happen. Eventually, the Knesset is the Israeli parliament, although they discussed it, although it was about to happen, it didn't happen because of the swing vote that the Orthodox Jews have in the parliament. And all through this time, gay couples and individuals kept going across the border and purchased surrogacy services elsewhere, right? Until something happened. In 2015, there was an earthquake in Nepal. Between 600 and 700 individuals, Israeli individuals, intended parents, were in Nepal at the time, waiting for their surrogacy babies to come out. And 25 babies were already born and stuck there in the earthquake with no electricity and a kind of extreme situation. And the media was burning. Everybody was talking about the story, and the awareness rose to the fact that gay people have to do so much more in order to have a baby and have a family that everybody deserves, right? So the media coverage was very sympathetic with the parents and with the difficulties that they have to go through in order to have a family. And there were cries, calls to bring them back. the Israeli government even considering bringing the surrogates, the pregnant surrogates, to Israel. The problem is that the pregnant surrogates did not have passports, so none of them came, right? And so along this discourse and this very clear narrative, there was another narrative that was a little bit marginalized, and that narrative talked about, you know what, there are questionable things happening in India with these surrogates, and maybe this is not the best solution for, you know, for women in general. This is, why are we allowing this sort of situation where we are sending Israeli citizens to potentially exploit women in other countries, you know, vulnerable women in other countries. This situation could have led to two options of narratives, right? One is maybe we should prohibit cross-border surrogacy because it is exploitative. The other one was maybe we should allow domestic eligibility to gay couples and individuals, so we can kind of control what's going on under the legal scheme that we already have going on in Israel. Kind of riding on this wave of empathy, in this year, a gay couple appealed to the Supreme Court and asked to change the definition of eligibility to domestic surrogacy in Israel, right? And they also asked that it will have nothing to do with genetics, that practically everyone could be eligible to surrogacy in Israel, right? The court denied the non-genetic relationship immediately, right? So that did not happen. But it said that it is willing to consider the other part, right? Open eligibility. The Knesset, the Israeli parliament, promised that they're going to discuss it, so the court's ruling remained pending. In the meanwhile, there was a lot of kind of activist action going on, and even the prime minister at the time, Benjamin Netanyahu, promised that he will support same-sex eligibility to these services, right? However, only in 2018, the Knesset really did something with this and kind of changed the law, but it changed the law only to allow single women, not single men or same-sex couples. And the reason was, once again, the swing power of Jewish Orthodox parties that, you know, threaten to take off the government if this thing goes. This, as a reaction, there was a very, very big gay protest in Israel. And everybody was in the street saying, love is love, the right to family is the right of everybody deserves it, etc. And it was very interesting what happened with the feminist organization, right? Because the idea of non-normative families is very appealing to the feminist organizations. Also, the idea of equality is something that both kind of organizations support, the gay organizations and the feminist organization. However, women organization did bring up the question of what are the implications on women when we kind of increase the demand to services that are provided with women's bodies, right? But those were kind of marginalized in a way, okay? And then in 2020, there was after the Knesset really did not address the same-sex issue, the case went back to the court, and in 2020, the court says, okay, that's it, I'm giving a ruling. the first thing that they said is that gender or sexual orientation does not change the aspiration of the right to have a family, right? That is also kind of a Jewish thing, right? Family is everything. And they did establish that this is what underlies the surrogacy law. I'm not sure that this is what underlies the surrogacy law, but this is what this is, if you want, again, this is the narrative that the court created, right? They also said that any equality argument outweighs the state support in restricting the market. Why? Because the state said two things. First of all, this law originally meant to restrict eligibility in order to protect women. Once you do not restrict the eligibility, then this is very burdensome on women's bodies and sends kind of the wrong message. Therefore, we're kind of opening up these risks again. The other thing that the court says is that if we allow increased demand, if you'd like, then we create shortage of surrogates for those who were originally eligible, and it will be harder for them. And we do understand that they have medical needs, and these needs are maybe stronger than the needs of the gay couples. I don't know. So again, the court says equality outweighs all of these other concerns that the state raises, but it does address them. And here I want to, before I start reviewing this, I want to say two things. The first thing that I want to say is that we have to understand the role of the court in establishing narratives and dominant narratives that kind of carry on in society, because that will make a difference. And the other thing that I want to make very clear is that the court did not abandon the discourse about the risks, the medical risks that that women's body bear because of surrogacy. They did address it. So what do they say? First of all, they address the argument that increased demand will increase the exposure to harm. And they say, well, this is exposure to medical risk is indeed a risk, but the harm that is done to the right to parenthood that gay people cannot exercise, this is far worse harm, and therefore we should address it. The other thing that they say is, again, kind of what I started with, right? So if we have protection mechanisms that protect surrogates and allow the women to undergo this very risky procedure, then those will protect any women in any scope of the practice, right? So it doesn't matter if it will protect one woman, it will protect 100 women in the same way, which I think is a very convincing argument. I think it's true. If it was a problem, then it would have been a problem for one woman as well, right? And then eventually what they say, surrogates autonomy overweighs the harm or any harm that we can, I mean, she knows what she's getting into. Everything is very clearly stated. We review, we understand, we know that she understands, and so that's not an issue. And then they talked about the other argument that is that women are really will be in shortage for those who are originally meant to use this process. And they say that there is no, they don't see any potential shortage because the amendment to the law expanded the eligibility of women to become surrogates. So now married women could become surrogates. There is much more supply of women that could become surrogates. And they also said that they reviewed the applications of cross-border surrogacy that was supposed to be kind of those gay people who want a family and go across the border to get it. And they say that 65% of it was from not same-sex couples. So only 45% were from same-sex couples. And this would not affect too much the supply of women. I don't think that the second argument is correct. First of all, 45% is a lot. But even so, what the court does not understand is that the court looked for application to register resulting children. What the court kind of forgot is for any resulting children, there might be much more than one woman involved. Many surrogates try and cannot succeed. There are miscarriages, there are things that happen in the way. There may be many more women than the number of resulting children, take-home babies, as they're called in a medicalized way. So what we can see here that by using the market terms like shortage, what happened to the narrative is that it constructs a certain vision. If we have a shortage in surrogates, then the market can provide, the market has answers to shortages, right? The market knows what we need to do, and the market is kind of constructs our vision towards the solution, and the solution is through the market. Definitely saying that there is a shortage in surrogates commodifies them. This is not my opinion. This is just a fact. If there's a shortage in surrogates, then surrogates are the commodity. And if there's rising demand to the commodity, then we need to find an answer again, an answer in the market. This is something that this narrative does again. What this also implies is that if we're in the market sphere, then in the market sphere, the market has its own rules, right? And if the demand rises, then we can talk about raising the price as well, right? And this could, like, at least if we're in the market, and at least if surrogates are being objectified, what can happen is that at least they could gain something from it and maybe make more money because they're in the market. However, no, the only thing that the court did in order to prevent this shortage for original intended parents was to say, well, there will be a maximum price, and the maximum price will allow all those who want to have children to be able to afford it. So the only thing that the surrogate could profit from when we're in this market narrative and market talk, that was the only thing that was denied from them. I want to state it very strongly because please remember that the agency, the lawyers, the doctors, everybody's making money from this thing. The only ones who are not making money of it, or who are forbidden from making money of it, are the surrogates. So here's my conclusion from the entire thing. If surrogacy is a legitimate market transaction, then it should be encouraged, right? Because if we talk about, for example, poor women who have the opportunity to invest in matches and become less poor and improve their economic situation, then we will encourage women to invest in matches, right? So if this is a legitimate thing, then we should encourage it and allow women to benefit. In this case, they should benefit from rising demand. However, if this is not a regular market transaction, then it should remain restricted not in non-discriminatory criteria, but remain restricted by other criteria that are maybe more equal, that apply equally to gay people and to other people. I think that we are kind of covering up something that is culturally and humanly disturbing to us. And the one who are bearing the burden of this cover up and inconvenience is women. And this is the argument of this paper, and I'm looking forward to hear your questions, pushback, whatever you have. Thank you very much. You're muted.
Indeed, I am. Now I'm not muted. Thank you, Sharon. That was very instructive, enlightening. You covered a lot of territory in a short amount of time, and we'll open up to any questions or observations, or use the Q&A and the chat. We may actually have some students at some of the colleges and universities that are attending in large groups. So if anybody has a question, just put it in the Q&A or send a message via chat. I'll start us off. In the earlier part of your presentation, you were making some of the sort of meta-ethical observations about this particular question, these particular concerns, and I'll sort of keep to those meta-ethical concerns with my question. The first is a sort of an Aristotelian question, because in an Aristotelian philosophy and in the ethics as conceived by Aristotle, what is ethical is when we work toward the good. So the first question here then is, can we say unequivocally that surrogacy is a good in the broadest sense of the term? And then concomitant with that is the Kantian notion of a categorical imperative. If we can say that surrogacy, for example, as you have defined it very, very meticulously here, if it is a good in the broadest sense of the word, is it a good that surfaces as universal in all cases without any contradiction, that would immediately sort of banish it from something that would be considered a moral imperative?
So what you're asking is so the question is, what is the moral imperative here? Well, is the moral imperative be fruitful and multiply? Is the moral imperative is not to subject, to treat someone as merely as means? There are many aspects that could be moral imperative here, right?
Truly, and that's the point of my question, to sort of flesh that out a little bit, because you talked about, and I'm just following up on your what you just said, is that when you were talking about this sort of the schizoid aspect of Israeli lawmaking, that is, it's a liberal democracy, but it also, there's a certain element of orthodoxy that comes from the religious nature of the state. One could also make that same claim, right? Because you have very deep-seated Jewish ethical concerns, but at the same time, as a liberal democracy, it's rooted in classic Greek philosophy, Western Enlightenment philosophy to root. So again, that there is some sort of possible competition there. So if you could just sort of flesh out are there any contradictions that would, yeah.
I think that there are definitely contradictions philosophically. However, and living in the United States as an Israeli, I encounter this a lot. There are some cultural presumptions that are stronger than any contradiction. So even again, even if we're talking about gay people, that they're kind of pushing back everything that is normative, but in Israel, they all want a family. This is so strong. This is so culturally embedded. The idea that family is about everything else, that you must have children. You can imagine every joke that you have ever heard about a Jewish mom asking her 20-year-old, I don't know, girl when she's bringing grandchildren to the pictures. So I think that this is much stronger. And I would say that, even in the Western liberal Democrat society, way beyond Israel in itself, I don't think we're living in somewhat peace with a lot of exploitation that is going on around us, right? In many things, right? In dumping and in people doing very difficult jobs, bodily works outside what we see. So in a way, it's a very convenient way to settle any contradiction. I will say this, and this is very important. There is a very strong intent of many gay and other organizations in Israel to make surrogacy fair, to make surrogacy just, right? Nobody wants to tell their children, listen, you were born because we exploited a woman, right? So they do try to make it not merely as means, right? But and in this case, when it is an Israeli woman, rather than someone who does not speak your language, who does not share your culture, I think it is even more helpful to kind of set an ethical environment and maybe settle this conflict.
Right. That's an excellent point. And what would be some of the criteria that would establish the practice as fair and just in your mind? I mean, I'm not looking for an exhaustive list, but what would be like the top characteristics of a fair system in this case?
This is the $1 million question. And in my book, I do try to build something like this. I will just kind of sketch the outline. I think basically there are several points that have to be taken into account and into the contract, right? So first of all, human rights and women's rights and women's rights to health should not be negotiable. Everything should be above the threshold of proper standard of care. The first thing. Second, there should be some leverage, some room for negotiation. This is a contract, and there's some things that have to do with autonomous decisions of the parties involved. For example, whether she aborts if there are abnormalities, whether she can go to work, whether she has, whether she's willing to have the number of fetuses reduced, all kind of things that should be subject to autonomous decision, and a contract could only happen if both parties agree on that. Then there's the registration thing, right? The registration of the babies, and this has to do, so I focus on cross-border surrogacy, so this has to do with children's right to make sure that no children would be stateless, or their right would be harmed, violated, because they were conceived across the border, right? But basically, I think the most unorthodox contribution that I have, I think, to the discourse, I talk about a recognition of the surrogate and her contribution as what makes a transaction ethical or unethical. And I think that we are often, and I've done it here as well, we often use exploitative, but there is a problem with using exploitative when we talk about a woman who chose freely to enter this thing, right? We should make it fair, we should make it just. And I think that part of it is really the acknowledgement of the surrogate contribution as part of this process. So, and that has to do maybe with keeping in touch with her after, unless she chooses not to, but not to leave it at the hands of the intended parents, to treat her as merely as a means, and also in favor of the children. There are a lot of children who are very angry at parents that they do not know anything about their surrogate. Mm-hmm. So this kind of combines the rights of all parties.
Now you talk about exploitation, and that's an extreme, and generally one could say that exploitation is, I don't want to say easy to recognize, but it's fairly visible. One of the things that concerns me is sort of the more subtle aspects of these type of relationships, where there could be coercion, which and I don't mean, violent or aggressive coercion. It could be the minute, for example, you talked about a monetary contract. Money itself can be seen as a coercive force. So how do you discern, if you can, how do you discern whether there's some coercion being exerted in these circumstances?
I think that my view is exactly kind of the mirror picture of what you're describing. Because again, if this is a weak woman or a vulnerable woman, and she needs money, therefore implied that money would be a kind of a coercive power for her, right? If this was a transaction that had no problem at all, you go and sell socks, we would encourage her to do this. I think that this is a camouflage. Saying that money is coercion is a camouflage to other concerns that we have about this transaction, right? Because if this is a legitimate transaction, then the fact that money is a coercion is not a problem at all. Like, money is a coercion, therefore I go and open my own business. Yeah, money is a coercion, and I open my own business, and everybody encourages me to do so I can earn money, right? We have a problem. If you're saying that money is coercion, it is kind of implied that you have a problem with her going into this sort of transaction. And I accept this, but then call it what it is. Okay. Right?
Well, Sharon, thank you for a quite enlightening hour. This has been terrific, and you're headed off to Drexel University, you said, next year. Well, good luck with that. Best of success to you on that, and continued success with your work. And you've got a book that you're working on, and hopefully we'll see publication fairly soon. Good luck with that. And
thank you for having me.
Oh, my pleasure. And we have still more to come this afternoon and into early evening. So please stay with the conference, and thank you very much again, Sharon. Take care. Bye-bye.
Thank you. Bye.